A proclamation is an official declaration. In English law, a proclamation is a formal announcement made under the Great Seal of some matter which the king in council or queen in council desires to make known to his or her subjects, e.g., the declaration of war or state of emergency, the statement of neutrality, the summoning a dissolution of Parliament, or the bringing into operation of the provisions of some statute the enforcement of which the legislature has left to the discretion of the king in the announcement. Royal proclamations of this character, made in furtherance of the executive power of the Crown, are binding on the subject, where they do not either contradict the old laws or tend to establish new ones, but only confine the execution of such laws as are already in being in such matter as the sovereign shall judge necessary. Royal proclamations, which, although not made in pursuance of the executive powers of the Crown, either call upon the subjects to fulfil some duty which they are by law bound to perform, or to abstain from any acts or conduct already prohibited by law, are lawful and right, and disobedience to them is an aggravation of the offence. And Case of Proclamations 1610, 12 Co. Wahida 74, Re. The Crown has from time to time legislated by proclamation, and the Statute of Proclamations 1539 provided that proclamations made by the king with the assent of the council should have the force of statute law if they were not prejudicial to any person's inheritance, offices, liberties, goods, chattels, or life. But this enactment was repealed by an Act of 1547, and it is certain that a proclamation purporting to be made in the exercise of legislative power by which the sovereign imposes a duty to which the subject is not by law liable, or prohibits under penalties what is not an offence at law, or adds fresh penalties to any offence, is of no effect unless itself issued in virtue of statutory authority. The Crown has power to legislate by proclamation for a newly conquered country, and this power was freely exercised in North America following the 7 Years' War by the Royal Proclamation of 1763, and in the Transvaal colony during the Second Boer War. In the British colonies, ordinances are frequently brought into force by proclamation. Certain imperial acts do not take effect in a colony until they are proclaimed, and proclamations are constantly issued in furtherance of executive acts. In many British protectorates, the High Commissioner or Administrator was empowered to legislate by proclamation. In the old system of real property law in England, fines levied with proclamations, i.e., with successive public announcements of the transaction in open court, barred the rights of strangers, as well as parties, in case they had not made claim to the property conveyed within 5 years thereafter. These proclamations were originally made 16 times, 4 times in the term in which the fine was levied, and 4 times in each of the 3 succeeding terms. Afterwards, the number of proclamations was reduced to 1 in each of the 4 terms. The proclamations were endorsed on the back of the record. The system was abolished by the Fines and Recoveries Act 1833.